We're waiting for Katya. I can see her. I see the first one is joining, but he's in a waiting room. So
Dasha, you are admitting them, yes?
yes, I will admit the first people, and then I will click the button that everybody can join without waiting in the waiting room. So I'm not clicking everybody because sometimes it gets frozen and people get angry.
So just tell us when to start.
Yeah, I think we need to wait a few minutes because only one participant in a waiting room. And Katya, and I cannot see Katya. I will drop her. Here's Katya. Katya, can you hear us? Can you say something? Katya, can you say something? You're muted. Can you unmute yourself?
Yes. Yes. Can you hear me?
Yes, we can hear you now.
Okay.
Tanya, will you be taking Graham's timing slide as per his email, or do you want me to do it? Just so I know.
Yeah, well, it looks like I will need to.
Dasha, I may need to switch video off for some time, probably, to save the battery.
Tanya, it's not that. Tanya, it's not that you need to. You just when I looked at it, there seemed very little for me to say, given that most of it's in yours. So I thought it'd be better. But if you still want me to do it, then that's fine. I don't think it makes sense to pass it to Louise, because the point I was trying to make is it's more natural for the same person doing both slides to do both.
Yeah, that's fine.
Igor, I suggest that we start the webinar. There are only 5 people right now in a waiting room, but I don't want them to be angry as they're like waiting to be admitted. So we can say,
let's start.
Yeah, and we can wait a few minutes and tell them that we'll wait a few more minutes to everybody to join.
Yeah, we can start. I'll do the introduction, and in the meantime, more people will join. So let's start.
So please mute yourself if you're not speaking, so we'll have a nice, we don't have a background noise.
Yes, Dasha, yeah.
And I'm admitting people now.
Hello, everyone, and welcome to our Restructuring Wednesdays webinar on distressed acquisitions. This is the third webinar that we do on Restructuring Wednesdays. And the webinar, as you see, is effectively focused on restructuring, various aspects of restructurings and various things that lawyers normally do in restructurings. Today, we have very exciting topic regarding distressed acquisitions, and as you may know, distressed acquisitions during crisis time becomes very hot topic, not only in Ukraine, but in other countries. So today, we are going to present very, I would say, detailed analysis of the issues which companies and buyers and sellers are facing when considering distressed transactions or distressed sales. So, who we are, first of all, and why we do this presentation. We have 6 speakers today. Myself, Igor Olokov, I'm partner and head of banking and finance practice at CMS Cameron McKenna Nabarro Olsvank in Kiev. We also have Graham Conlon, our managing partner and head of private equity, and also heading private equity not only in Ukraine, but in CEE and CIS countries. We also have Tatiana Dolgan, our partner and corporate doing M&A practice in Kiev. We have Katerina Chichurina, our counsel in banking and finance. And we have Christina Korpan, associate in banking and finance, and Luis Sakar, who is doing also M&A work as English solicitor here in Kiev. So first question regarding who is CMS. As you see from this slide, CMS is one of the largest law firms in the world. In fact, the 5th largest globally in the world, and the largest law firm in Europe, and in several markets, including UK, Germany, and Ukraine. We actually are the leading law firm doing M&A work, and specifically distressed M&A work, about which we are going to speak today. So before we actually proceed to the topic of our presentation today, distressed acquisition, I wanted to highlight a few words, what we actually did in the past on the webinars, and what we plan to do in the future. First of all, because of this pandemic situation and because of this global crisis which this pandemic situation has brought, we have decided to hold Restructuring Wednesdays webinars, and we have already held 3 of those webinars. The first one was devoted to debt restructuring, doing it right. And it was held in April, just when the crisis was actually very actively discussed, and we were already actually thinking about this webinar. We also had very popular webinar among our contacts and clients regarding foreclosure and collateral, and a general webinar about the influence of COVID-19 on financings in Ukraine. So all of these past webinars which we held, you can access them on demand anytime. We will provide links to the materials and to the presentations after this webinar. You will receive them by email, and will be able to watch them at your convenience. We also plan to hold, continue our Restructuring Wednesdays, and the next webinars which we are going to hold will be devoted to privatization in Ukraine. And in September, we are going to repeat our seminar on debt restructuring, doing it right, but describe latest tendencies which we have already noticed by September with restructurings. And in October, we are going again to repeat the webinar on foreclosure of collateral, again, based on the most recent experience and the changes which have happened by October with the pandemic and generally with the business situation. Also, because we have spent quite a lot of time on actually restructurings and various projects relating to distressed acquisitions, here we are sharing with you some materials regarding restructurings, regarding the implications of COVID on financings, on distressed acquisitions. And most importantly, CMS produced, together with major markets, a very detailed report regarding the latest tendencies or outlook for M&A and distressed M&A. And you can also access this information, and we will provide you links after this webinar. So why distressed acquisitions? As you know, the world is, and Ukraine as well, like any other country globally, is now facing a great lockdown. The statistics of the International Monetary Fund at the beginning of the year in January indicated that the global economy will grow by at least 3% by the end of the year. However, by the middle of March, their forecast changed dramatically, and now they expect that actually the global growth will not happen, and there will be, in fact, a downturn of around 6% in the world economy by the end of this year. So, and this is an unprecedented crisis which has never happened in the world history. So we are in uncharted waters, so to say. So because nobody knows what will be the final economic consequences of this crisis and this uncertainty. Obviously, COVID was one of the reasons for this, and it has created a great recession, possibly. Although I don't want to sound pessimistic and to say that it is the end of the world, I would say that this crisis has very unique characteristics, which basically make it, first of all, it happened very quickly, and then we can obviously expect the same quick rebound to a different phase of development. And hopefully, this will not be as bad as it is described currently by the economists. In Ukraine in particular, the current expectation is that the GDP will actually fall by around 5% by the end of the year. So we are slightly better than the expectation which the IMF has for the world economy. So now, based on the European M&A outlook and the survey which was held by CMS and Merger Market, again, you can access this full survey on our website, but you see that the role that everyone who participated in the survey, in fact, more than 90% of people who participated in the survey, they believe that with this crisis, the role of distressed M&A will increase significantly, and that restructurings and distressed M&A will be actually the hottest topics that the lawyers and the financial advisors and everyone will have to deal with in the immediate future. So which sectors are mostly affected in Ukraine and CEE regions and CIS regions by the current crisis which we have? We have prepared this nice table which summarizes basically the sectors which are mostly affected by the pandemic, by the crisis. As you will see, some of these sectors like airports, automotive, transport, and other areas, tourism, they have faced an unprecedented pressure to their revenue. Some of these businesses, they do not have any revenue at all because of this lockdown and quarantine measures. The others basically also experience significant downturn. So there will be many changes in these industries. And This creates a lot of uncertainties for prediction of what will happen, what needs to happen, and of course, this is a time for opportunities for actually for these businesses to streamline their and to find ways to actually get rid of unnecessary assets and maybe to do restructurings and other things which they have not done in the past. So now a few words what we are going to speak about. We expect that there will be a significant rise in distressed M&A in Central and Eastern Europe and in Ukraine in particular because of this pandemic situation. In Ukraine, of course, the situation is that we still live through the legacy of the banking crisis, and we have a lot of distressed assets which are sold by the banks and by the Deposit Guarantee Fund. And now actually the situation with pandemic has actually aggravated this situation, and that, for example, state-owned banks, they now embark on a program to sell their NPLs, their bad assets which they have on their portfolios, which they have basically discussed for 5 years and which never happened. But now is the time for this to happen finally. And also the same with privatizations. And most of the assets which are subject to privatization, again, are not in a very good shape. So this will be distressed operations. You will see that we will later describe during our webinar that this is the buyer's market, and effectively, if some of the buyers have enough powder to actually purchase something, it's a very good time to start thinking about M&A activities and to start looking into Ukrainian market in particular and CE markets, because now you can get the assets which in the past were impossible to get the pricing which is offered now. And of course, because of these specifics of distressed M&A, there are a number of issues which need to be taken into account. First of all, the timing pressure and of course, moratoriums which exist in many countries. Last week, as you know, Ukrainian parliament passed law 3322, which effectively introduces moratorium for initiation of bankruptcy proceedings. It has not yet been signed by the president, but will be hopefully signed soon. So this will also affect the process of doing restructurings and distressed M&A in Ukraine. Now, I want to emphasize that to the participants that you can always on Zoom ask questions, and we will be pleased to respond to them. If we do not find time during the webinar to respond to your questions, we will definitely get back to you and we'll give these responses by email or other means of communications after the webinar. So do not hesitate and give us these questions either to our personal contacts or to the chat room here on Zoom. Now I pass the floor to Graham to continue our webinar and to describe our experience in distressed M&A area.
Thank you, Igor. So just a few words about the team and our M&A capabilities in Kiev. As you can see from a few representative credentials that we have on screen here, we advise on the full range of deals from small to big, from local to multi-jurisdictional. Some of the bigger, more high-profile deals that we've been involved in recent times include the DP World joint venture. This is the joint venture which brings DP World to Ukraine, a deal that closed about a week or so ago, and very high profile. Other transactions recognizable that we've worked on include Cargill joint venture, P&O joint venture, transactions for EBRD, Horizon Capital, Advent International, etc. If you move on to the next slide, please. And the next slide. And here's a selection of some of our distressed M&A credentials in particular. So to bring out a couple of those, H&A, for example, is a good one. This is, H&A is a global, huge conglomerate. We advised from Kiev on a major deal across 17 jurisdictions. Another transaction on which we recently advised includes the sale of Aladdin Mall in Kiev, which you will all know. This is also a high-profile transaction. And we advise on the full range of work from on the ground in Kiev, so beginning to end of the transaction, not just under Ukrainian law, but also under English law, given that many transactions are governed by English law, and also coordinating all other jurisdictions that may be involved. Next slide. So what do we do in a typical process? Again, from beginning to end of the transaction, we would typically start with advising on acquisition options, advising as to transaction structures. We help to develop a strategy. We assist with due diligence. That's either buy side or sometimes even sell side, for example, vendor due diligence. We assist with the drafting and negotiation at all stages throughout the transaction, whether under Ukrainian law, English law, or other laws involved. And we handhold and lead the client from beginning to end of the process. Next slide. So what can you expect today at this seminar? So we are going to talk about some of the sectors for distressed acquisitions in Ukraine, and Igor has touched upon that already. Some of the key differences between distressed acquisitions and regular acquisitions, some of the risks associated with distressed acquisitions, some issues you may wish to consider in the context of due diligence, some transaction structuring related questions, and also we're going to touch upon timing and also some of the implications either before or after the commencements of insolvency proceedings. I pass the floor.
Thank you, Graham. So I will be dealing in these next few slides on the key differences between regular or healthy acquisitions and distressed acquisitions. At a high level, distressed acquisitions may initially seem, which take place outside of formal insolvency proceedings at least, fairly similar to non-distressed M&A deals. For example, the transaction documents are likely to cover some of the same deal concepts, and they're generally subject to the same array of consents, etc. However, as this is a distressed acquisition, just below the surface, often there will lie significant issues that purchasers will need to consider when pursuing the acquisition of a distressed asset. As a result, the types of acquisitions vary in many material ways. So the first one I would like to touch upon is the increased time pressure. Now, anyone that's worked on any regular M&A will know there is always time pressure in an M&A process, but this is particularly heightened in a distressed M&A. The main source of this pressure is of course the worsening financial position of the target. For this reason, the seller will be seeking to complete the deal as quickly as possible in order to maintain the value of the business and also to maintain to protect the business's reputation from a formal insolvency process. In addition, pressure is on the directors. So the closer the company becomes to insolvency, the more duties which the directors will be under. For example, if the company becomes unable to settle its debts towards its creditors, having already settled its liabilities towards one of its creditors, they will be obliged to file a bankruptcy proceeding within 1 month. So there's obviously a lot of pressure on the seller side and on the directors, but in contrast, an investor, for example, may frequently play for time. And the reason for this is to potentially obtain a more attractive price for the target or the assets as the financial position of the target continues to deteriorate. However, that's not to say that there is no time pressure on the buyer. And if the asset is particularly desirable, and in the market that we have now, where there may be some quite high-profile companies that are actually undergoing distress because of the COVID-19 situation, there may be competing bids for that asset or for that target. So in that scenario, the buyer will be under some pressure to complete the acquisition as soon as possible. And often, in a distressed M&A scenario, there will not be exclusivity arrangements in place. So that will place some pressure on the buyer as well. In addition, the buyer will often have less time in a distressed M&A to conduct its due diligence. So this will again increase the pressure on the buyer. Next slide, please. So another important way in which distressed asset acquisitions are different is the transaction structuring. Now, naturally, all M&A transactions will require some element of consideration for structuring, but additional consideration is needed in a distressed scenario. My colleague will discuss in more detail transaction restructuring later in the presentation. But in summary, the main points to consider will be how to structure the sale in order to avoid the risks identified in the due diligence process. So this could include, for example, a share sale. If you're going to undertake a share sale, at what level should you undertake this? Perhaps at the operational level, potentially a foreign holding company, or indeed at the level of a new spin-off entity. This is in comparison to an asset sale, and if you do go down the asset sale route, my colleague will explain the advantages and disadvantages of doing so. You will need to consider whether you wish to acquire the entity as the business as a going concern, or a particular category of assets or specific assets. In traditional M&A, of course, share sales are the most common. So the fact that asset sales are preferred in distressed, often deferred in distressed M&A is one distinction. However, I would like to just note that although asset deals are often preferred, this might not always be appropriate, particularly if the jurisdiction in which the assets are located attracts a high level of taxation to the transfer of assets, or potentially in a multi-jurisdictional deal, undertaking the transaction as an asset sale could be quite complex due to the increased execution risks connected to the transfer of those assets. The final consideration, which will be different in a distressed asset situation, is the timing of that acquisition. So will the buyer want to purchase the target of the assets prior to formal insolvency proceedings commencing, or after? And my colleague will be touching on the advantages and disadvantages of that later in the presentation. Next slide, please. So pricing and buyer security. So this is a very key difference with distressed M&A. So in a distressed M&A scenario, the target or assets are often sold on an as-is, where-is basis. This essentially means that the asset is often being sold for a significant discount or even below market value. And consequently, naturally, in this situation, a seller is not going to be willing to provide the usual suite of protections to the buyer in the form of extensive warranties, indemnities, or potentially purchase price adjustments or escrow arrangements. Basically, what we're saying in a distressed asset scenario where the target is being sold as is, where is that the buyer can take it or leave it. I will be discussing this issue in more detail later when we look at the main risks associated with distressed M&A. But it basically means that in the absence of the usual suite of contractual protections for a buyer, significant emphasis should be placed on conducting a very thorough due diligence process to ensure that all risks are identified and priced into the purchase price. I'd just like to touch upon anti-embarrassment provisions. So as a result of the lower price, it's possible that some sellers will seek to negotiate the inclusion of anti-embarrassment provisions into the transaction documents. The purpose of this is essentially to prevent the buyer from purchasing the assets at a low price, and then in a very short period of time selling those assets on for a significant price increase. So the seller may wish to prevent this to stop itself from being embarrassed, let's say, but whether that will be accepted by the buyer will obviously depend on the relative negotiating strength of the parties. And the final point to touch upon on this slide is W&I insurance. So in the absence of warranties, indemnities, and potentially the seller not having a sufficient financial standing to even meet its claims under those warranty and indemnities, if they are included in the transaction documents, the buyer may wish to address this risk through the use of W&I insurance. My colleague will briefly discuss this in the context of due diligence. However, it's worth noting that a distinction between traditional M&A and distressed M&A is that W&I insurance is less likely to be available in a distressed M&A scenario, and that is often because the insurer is not satisfied with the level of due diligence that has been conducted in the short period of time. This is particularly the case in Ukraine, where the W&I market is still at a very early stage of development. However, it is worth noting that CMS just last year completed a distressed M&A sale where W&I insurance was obtained. So although it's unusual, it is possible. Next slide, please. So the final distinction I'd like to discuss between regular and distressed M&A is the financial related matters. Now, my colleagues will deal with this later in the presentation. But just briefly, as we've already discussed, the main distinction naturally of a distressed M&A is that the entity or the operation of the business is not financially self-sustainable. As a result, in addition to focusing on the actual sale and purchase of shares or the assets, the buyer will need to pay particular attention to the financing of the target or the business going forward after completion. And we'll also have to consider how to handle, where relevant, any existing financial arrangements. Depending on how the transaction is structured, this could include, for example, consideration to recapitalizing the target, paying off its existing debts, or otherwise restructuring the existing financing. Such arrangements will also be relevant to determining the purchase price and may require analysis from a tax perspective. The last point just to mention on that slide is the potential for voidability. Again, this will be touched upon in more detail later, but just to note that the buyer should be wary that if the transaction is happening at an undervalue, there is a risk that the transaction could later be declared void in the event that the company goes into administration within 3 years from the date of that acquisition. But my colleagues will be talking about that in more detail, and we'll also discuss how we can mitigate those risks. Next slide, please. Okay, so now I'd just like to touch upon the main risks that are associated with distressed M&A acquisitions. So firstly, the first point is there is a problem. Of course, by definition, in a distressed M&A, there is obviously a problem, but as they say, where there is danger, there is also often opportunity. What is important is that the problem is accurately identified, that we fully understand the reason for the distress, and that the buyer has assessed the possibility to create value. Of course, there is no point in considering the acquisition if we can't turn it around. This is naturally primarily a commercial concern. But so just for example, there's some questions the buyer should be asking itself when it's identifying the problem and assessing the value. Is things like, how did the business get here? What can I do to turn it around? What needs to happen to make this business profitable? And indeed, what could go wrong, so that the buyer is prepared for every eventuality. I think something to note here is that it's the situation may be changing rapidly. So, for example, on Monday, the acquisition could seem like a profitable investment, but by Friday, this may not be the case. So it's important to stay on your toes in a distressed acquisition and to be constantly weighing the identified risks against the attractiveness of the price. So this isn't something just to do at the outset, but constantly throughout the transaction. And for the seller, it means that they should be taking all steps to avoid any delays to the transaction. Obviously, they want to complete this as quickly as possible to protect the target's reputation and financial position. So moving on, the next 2 points, the next 2 key issues are sort of interconnected. So firstly, we have the limited protections for the buyer that we just discussed. So as I mentioned, when the pricing is on an as-is, where-is basis, the seller is probably offering the asset or the target a very deep discount. They are not going to be wanting to have lots of residual liability towards the buyer post-closing, and for that reason, they're not going to be wanting to offer warranties and indemnities and post-closing adjustments. A particular thing to note here is that commercial warranties are more or less non-existent in a distressed asset scenario. They're not very likely to be given at all. And for that reason, as we mentioned earlier, all risks should be taken into consideration into the purchase price in order to strike the correct balance between this opportunity and danger that we mentioned in the previous point. So if we don't have the full suite of contractual protections, if there are limited warranties, indemnities, etc., how can the buyer protect itself? And as we would discuss more later, the real way to do this is through a very thorough due diligence process. Although often in a distressed M&A, there may be less time in which for the buyer to conduct its due diligence. And for this reason, my colleague will later be discussing how to conduct a good due diligence in these circumstances. So connected to that point is the creditworthiness of the seller. So if you are a lucky buyer and you have managed to secure in the transaction documents some warranties and indemnities or other contractual protections, you should still be asking yourself is, post-closing, if I need to make a claim, will the buyer be able to be in the financial position to meet those claims? If the answer to that question is no, it will not, you will need to be looking at things like holdback or retention of monies in escrow, or potentially a guarantee from a creditworthy affiliate. However, these options are usually not available in a distressed M&A transaction, which is why, going back to the previous point, we always recommend that to the greatest extent possible, all risks and liabilities are identified and priced in to the purchase price. Next slide, please. Okay, so the next key issue is potential past encumbrances. So given that the business is in distress, it is likely that it is affected by a variety of encumbrances which should be identified in the due diligence process. So how do we approach this? How do we deal with this risk? Well, that will depend essentially on the type and the significance of the encumbrance, but it's likely to be taken into consideration in the transaction structuring. For example, in the case of a very heavily encumbered entity, the purchaser may wish to structure the asset as an asset sale to allow itself to cherry pick those assets it wishes to acquire and to leave behind those liabilities which it does not wish to acquire. It's probably worth noting that it's not always possible, depending on the jurisdiction in which the transaction is taking place, to avoid all liabilities, even in an asset sale. And this is because certain liabilities will attach automatically to an asset by operation of law. This is less of an issue often in Ukraine, just taking the example, which is often given of environmental liability, for example. In Ukraine, environmental liability will generally attach to the owner or operator of the asset and will not transfer to the new owner. However, in practice, people that need to bring claims in relation to that are likely to be in contact with the current owner, so it can still cause some issues for the buyer. So it's worth taking into consideration. The next issue is the involvement of creditors. So unlike in a healthy M&A where the parties are essentially likely to be limited to the buyer and the seller, potentially some parent companies might be involved. In a distressed sale, this is different. Regardless of whether it's undertaken prior to insolvency or in insolvency, an array of third parties are likely to be involved. So in an acquisition prior to a formal insolvency, those third parties are most likely to be the company's creditors. So how can we deal with that issue? I think the key here is early engagement. So you may need to liaise with those creditors in order to obtain a variety of consents. That's regardless of how the transaction is being structured. And particularly in a share sale, you will need to give special consideration to the existing financing that is in place. So you'll need to consider whether you're going to keep that financing, pay it off, or restructure it. And early engagement with the creditors will allow you to address those issues and avoid any delays down the line. It's also important here, I think, to be wary that the duties or the sort of attention of the current management may be focused more on the current on the creditors. And so for this reason, if they're busy, keeping the company essentially afloat and complying with all their statutory duties, they're probably going to have less time to be dealing with a buyer's due diligence requests for information and documents. It's just something to bear in mind there. So the final issue I'd like to touch upon is, again, voidability or transfers at an undervalue. So acquiring a business or assets outside of a formal insolvency process means that the buyer is potentially exposed to the risk of the transaction subsequently being challenged. As I mentioned earlier, this is relevant if the company goes into insolvency within 3 years of the transaction. So how do we approach this risk? My colleagues will deal in detail with the mitigation, but just in summary, it's important for the whole process to be conducted by the seller with integrity and openness in order to try and achieve the best possible price for those assets. How could we do that? Well, that could involve potentially obtaining a third-party expert opinion on the fair purchase price, which should apply, and ensuring that that fair purchase price is documented clearly in the transaction documents. Just another note here about anti-embarrassment provisions. We mentioned this earlier, but it's also quite relevant in the context of voidability. For example, if the buyer is able to purchase the assets for a low value and then in a short period of time quickly make a profit on the resale of those assets, that would point to the fact that the transaction did not take place potentially at a fair value and could be grounds for challenge in the future. So it's something to bear in mind. So that was a quick whiz through the key risks of distressed M&As and how they differ from a healthy M&A. And now I'm going to hand over to my colleague Tatiana to discuss the structuring considerations.
Hi, everyone. This is Tatiana Dovgan speaking. You will not see me on video during this webinar, unfortunately, not because I'm camera shy, but because of some technical issues on my side. Apologies for those, but hopefully this will not affect the messages that I'm about to deliver. So there are two main deal structures, which are used both in traditional M&As and distressed acquisitions. The distressed acquisitions can be structured at the level of Ukraine or outside of Ukraine, so our considerations would be quite common for these two. Business and asset transactions can range from an acquisition of entire business as a going concern to the acquisition of one division or category of assets or specific individual assets only. We do expect that due to the coronavirus crisis, we're likely to see a material increase in the use of asset sales. From a seller perspective, when doing a deal, a tax is one of the main reasons to use a share deal, but this factor is often much less relevant and a decisive factor in the context of distressed deal where valuation is subdued and the seller gains are less likely. As a result, the buyers, especially with a strong negotiating position, frequently seek to choose the assets they want to acquire and leave as much liabilities behind as possible, including unknown and contingent liabilities. So an asset deal may seem like a perfect solution, a perfect deal structure for the buyer from the liability perspective, especially in circumstances where the target company is in distress. In reality, business and asset transfers can be a lot more complex to implement than share deals. And the complexity will largely depend on the number and category of assets being acquired. If we talk about the business transfer, which means the transfer of all assets, then compared to a share deal, we are looking at a greater number of third-party consents to be obtained for transferring the assets, for leases, for example, for permits and licenses, although some may not be transferable at all, for commercial contracts, which means that these transactions will take longer to complete and will have more risks from the perspective of the deal certainty for both parties. There's also complex documentation. You will essentially need an instrument of transfer for each category of assets, and if not done properly, then legal title may be inadvertently left behind. So this should be looked out for. And consequently, the costs, legal advisory costs associated with such asset deal will be higher as well. And exactly for the reasons that I've mentioned, the seller may push back on the asset deal structure because the timing is normally of the essence in deals like that, and deal certainty are very important in the context of distressed acquisitions. The concern around obtaining various third-party consents for asset transfers is especially relevant in the current coronavirus environment, when governmental authorities, consenting parties may be operating with restrictions, some may be resource constrained, which means that consents may take longer to obtain and can cause potentially significant delays for the transaction. Also, if we talk about the asset transfer deal, then whereas it allows to choose the assets that the buyer would like to have with no liabilities attached to them, such cherry picking may not always guarantee a seamless continuity of the operation of such assets because of the potential need to renew some permits and licenses. And in some cases, especially in Ukraine, those are attached to an owner, operator of an asset, and therefore can only be obtained after the transfer of ownership. All of the considerations and concerns are relevant for most jurisdictions, and in particular relevant for Ukraine, and therefore asset deals are less common in Ukraine generally, but a bit more common in the context of distressed acquisitions. We have done quite a few asset deals in Ukraine as well as outside of Ukraine, and they're not easy by any means, and they're time consuming. And the last point on the asset deals in Ukraine, there will be VAT on the sale of assets in Ukraine, which includes inventory, equipment, real estate, with a few exceptions though. The VAT on the asset transfer is not always a bad thing. For a domestic buyer, Ukrainian company that is registered as a VAT payer, in most cases, it will be able to recover such VAT in the future. However, if the buyer is a non-resident buyer, then obviously there will be a lot of disadvantages for structuring a deal like that. And in reality, nobody really uses a foreign entity to acquire Ukrainian assets directly. So that takes us to a share deal. Yeah, it is much simpler to implement. It may be done quicker compared to a complex business sale. It certainly ensures business continuity without the need to renew permits and licenses or contracts or enter into new contracts. The seller is more likely to be solvent than its subsidiary and will be able to provide at least a limited set of warranties and indemnities. But again, as my colleagues have mentioned, there may be no protections at all in the SPA in a real distressed scenario. But the main issue with the share sale option is that a buyer assumes all historic liabilities for the company, which may not be known to the buyer, given that normally due diligence is done within a much shorter time period, and all the buyer queries may not be addressed by the target, by the seller, in the similar manner as in a regular transaction. So are there any other options how to structure such deals? Next slide, please. Another option is sort of like a hybrid between asset and share deal and is used when parties cannot reach agreement, in particular on purely sale or asset deal. The assets that the buyer wants to acquire would be carved out to a clean new entity, and then such entity would be sold to the buyer. If the circumstances and importantly the timing, as it will take some time to implement this restructuring permit, the structure could yield better results for both the buyer and the seller and could improve the deal certainty. It will help the seller to realize greater value for the assets being sold because there will be generally no historic liabilities associated with the transfer of assets and with this new clean company. And the buyer is more likely to be able to complete due diligence on a clean entity within a relatively short period of time and be comfortable with the assets that it's acquiring. However, with this option, it is essential for a buyer to clearly assess and understand whether the transfer of assets to a new company is clear and free of any encumbrances, whether any third-party consent would be equally required, and whether there will be any associated liabilities that will follow those assets. In Ukraine, generally, no liability will attach to the assets being transferred as such, however, with a few exceptions. So those will need to be looked at and analyzed pretty closely. So next slide, please. Due diligence in the context of a distressed acquisition has somewhat different flavor than due diligence in a traditional transaction. On one hand, a potential buyer of a distressed company should take extra care to conduct a thorough due diligence investigation to be able to identify all the liabilities and to also better understand the reasons for the distress, how the company got into trouble. This is especially relevant given that the warranty's indemnity protections will be limited if available at all. Warranty indemnity insurance may not always be available as well, especially in Ukraine. It has always been a very expensive instrument and not very commonly used. However, we do see an increased use of this instrument in recent years. On the other hand, there is usually very limited time to conduct a due diligence. Moreover, in most of the cases, the management of a distressed company will be more focused on sorting out more pressing matters of the company rather than attending to each and every request of the buyer. This is also relevant, especially relevant now in the coronavirus times when the buyer and the seller may both have actually limited resources to devote to the due diligence, assess paper records, conduct site visits, and this may not even be possible in some jurisdictions, and depending on the restrictions, the current state of the restrictions in Ukraine, this may not be even possible at all. So this should be kept in mind. And therefore, in the context of a distressed acquisition, our recommendation would be for the buyer and its advisors to do some homework before even starting the due diligence exercise. The homework should include gathering as much information as possible about the target, the state of assets, encumbrances, litigation proceedings from public sources to be able to understand ideally at the outset whether it's going to be an asset or share deal. This will enable the purchaser and its advisors to focus on super material issues only, which is very important in the limited time available for due diligence. If it's clear from the outset that it's going to be an asset deal, then the focus in the due diligence should be on the assets to be transferred, transferability issues, the need for third-party consent, and therefore the buyer and its advisors won't need to spend time looking into historic share transfers, potential historic liabilities, and other things that normally advisors look at when they do a share deal, and vice versa. If it's a share deal, then obviously no need to focus on the transferability of assets. It is therefore fundamental that the buyer, especially the buyers who are less experienced with distressed acquisitions, engage experienced advisors who are able to quickly distill the issues and help the buyer focus on material issues only. Otherwise, the buyer risks dragging the due diligence process and causing extra stress for the seller and the target, which may result in the seller's dissatisfaction, especially when a sale is a competitive process. The seller may be unhappy with the approach taken and may actually proceed with doing a deal with the buyer who may be a bit more reasonable and pragmatic in its approach towards the transaction and towards the due diligence in particular. Next slide, please. So now on to the timing. So far, we have focused on structuring the deal and considerations at the pre-solvency stage. And my banking colleagues will shortly talk about the acquisition of assets during the insolvency stage. And here on the slide, you see the main differences between the two options. The transaction considerations, transaction structuring considerations will be very similar, so we won't be stopping at those once again. But if we talk about the negotiating the deal prior to insolvency, then there's a lot more flexibility. There's a lot less publicity. then the purchaser will have normally a bit more time to conduct due diligence than during the insolvency. And generally, it will be a much faster and more kind of convenient acquisition than during the insolvency. However, the key disadvantage of the acquisitions during the insolvency is that, I mean, in contrast, that it's a very, very formal process. There is not much room for negotiation. There are various parties involved, which drags the process. So do not expect this to be a very streamlined process, compared to a share deal, when negotiations are mainly done between seller and buyer and potentially some creditors, and banks. However, the key difference and the key concern here is the voidability risk. It exists in the context of asset deals. This risk exists in many jurisdictions, including in Ukraine. My banking colleagues will touch upon it in greater detail, but essentially, if the assets are being sold under value, then there is a possibility of challenging this transaction afterwards. So this is the main kind of downside of the share deal being done, of the asset deal, done prior to the insolvency. And therefore, during the due diligence, special focus should also be made on some historic transactions with the assets to identify any potentially undervalued transactions. The next slide, please. Yeah, so here, again, when we talk about the timing, we will not be going over the advantages and disadvantages of sale of assets and the share of assets, because the considerations will be very similar to the ones that I have already discussed, but obviously the greatest risk of acquisition prior to insolvency is voidability, and also this is something that has to be properly dealt with in the transaction documentation, and how it should be done and what are the mitigating factors that should be considered will be touched upon by my colleagues now. Over to you, Katya.
Thank you, Tanya. So can we please move to the next slide? Right, so indeed, the risk of voidability is the greatest risk in distressed M&A deals. While such risk generally is there for normal M&A transactions as well, still, given that the seller in a distressed M&A transaction would already be likely in a situation of financial difficulties, the risk that it may go into insolvency and accordingly the voidability risk is higher than in any transaction carried out under normal circumstances. Such risk, as mentioned, exists in many, if not all, jurisdictions, and in principle it's the same, except for some jurisdiction-specific peculiarities. So what the voidability risk is about? It is the risk arising from so-called clawback rights of an insolvency officer or debtors' creditors within the insolvency proceeding. Such rights suggest that an insolvency officer or creditors within the insolvency initiated against a debtor, a seller within the M&A deal context, can challenge the transactions which were entered into within a certain period of time prior to initiation of the insolvency proceeding, and such transactions can be declared void. If a transaction is so declared void, that would further mean that whatever was received by a debtor's counterparty under such transactions would need to be returned to the debtor, and any claims that the debtor's counterparty would have under such transactions can be satisfied only within the insolvency procedure and according to the rules of the same, and according to the priority order set by law for the creditor's claim satisfaction. Good news is that not any transaction would be at risk, but only those transactions that would satisfy the criteria set by law. And based on such criteria, we can have such a high level split of the transactions which are at risk into two groups. The first one is the transactions without adequate consideration, and the second group is preferential transactions. So while more specific criteria can be set in various jurisdictions, yet the basic criteria for the first group of the transactions is that the terms of such transactions does not provide adequate and sufficient consideration to a debtor for whatever a debtor disposes. So it is either too low price for the assets or some other disproportionate conditions, consideration received by the seller, or disposal or transfer of the assets without any consideration at all. Similarly, it may be the transactions which under which the debtor grants a waiver to its counterparty, for example, a waiver of a payment that is due, and given the circumstances, such waiver is not appropriate, is not favorable for the debtor. These transactions may also be the transactions intentionally detrimental for creditors, or intentionally hiding or delaying insolvency of a debtor. And finally, this group also includes the interested parties transactions, which, given the related parties are involved in those, may not necessarily be on an arm's length basis, and such may cause risks and damages for the debtor's creditors. And the second group of transactions is more specific in a way that these transactions are aimed at giving preference to one creditor to the detriment of others, as opposed to the first group of the transactions, which would usually affect all of the creditors of the debtor. So the most obvious example is the early payment of a debt to one or several creditors, or granting security in relation to a debt that was previously unsecured, or generally granting security to one of the creditors. That could also be assets for debt swaps, and any other transactions having the similar effect. What is important in relation to the voidability risk, and I please ask to move to the next slide. So first, it is that mainly such voidability risk would be relevant for the asset deals, where the seller is a company in distress and thus potentially would become insolvent soon. As regards share deals, such risk would be relevant if the shareholder of the target that sells the company itself is in financial difficulties position, and accordingly runs the risk of insolvency. And secondly, it is the timing that impacts the level of the risk and the duration of such risk existence. So here we're talking about so-called hardening period, which is some period prior to the initiation of the insolvency. It is only the transactions which were entered into during such period that can be challenged and declared void. Such period may vary from 6 months to 6 years, or even more in various jurisdictions. For example, in the Netherlands, it is 6 months. In Ukraine, it is 3 years period. And this was lately actually extended. So previously it was 1 year, but extended to 3 years under the new bankruptcy code. And this period is now aligned with the statutory limitation period, which is also 3 years. So effectively, it would depend on a jurisdiction where a seller is located as to how long the voidability risk would exist and which transactions could be affected. And on this slide, we have the transactions which can be voidable under Ukrainian bankruptcy law. And as you can see, they generally fall within parameters we discussed on the previous slide. And the one peculiarity, though, is that there is an additional criteria that would determine whether or not a transaction can be challenged, and that is the absence or existence of damages. So, for example, if there is an early performance, then such early performance can be challenged only if, as a result of such early performance, damages were caused to a debtor or to creditors, as opposed, for example, to the deed of gift, which can be challenged irrespective of whether any damages were caused by such transaction. Another important aspect to note is in relation to the purchase of assets. It is important to avoid long-term deals, meaning that such deals suggest that the performance under such deals would take place in more than a 3 years period. Why is it important? Because the insolvency officer has cherry-picking rights during 3 months after the rehabilitation procedure in the course of insolvency to actually not perform the transactions that can cause damages to the debtor, or the transactions which are long-term, more than 1 year, and have only long-term benefit for the debtor. And also if the performance under such transactions would prevent the rehabilitation of the debtor. So this means that even if a transaction was entered into earlier than 3 years period prior to the insolvency, but the performance under such transactions is to take place, for example, within 5 years, such a deal and such performance can also be at risk during the insolvency proceeding. And finally, the risk for a buyer is that the claims that the buyer would have in relation to such void transactions could be satisfied only within the usual priority lines, which is together with the satisfaction of the claims of all other unsecured creditors. So how to mitigate the risk? What one can do to mitigate that? And please let's move to the next slide. So as already mentioned, clearly careful due diligence of the counterparty, and in case of a share deal, of the past transactions of the target, something that would be recommended in order to identify whether there are any issues. The most straightforward, though not necessarily the easiest one, mitigation would be to obtain an expert valuation in relation to the assets purchased. This would help to mitigate at least the risk associated with the unfair pricing or undervalue. Further, also mentioned there may be various contractual protections requested. Again, this would be available mainly in the share deal, though in relation to the assets deal, the buyer may also try to request various guarantees and indemnities from a shareholder of the seller. Of course, the financial position and condition of the shareholder itself would be relevant in terms of the quality of such protection. Also, where there is no clear evidence of the commercial benefit of such transaction for a seller, it's not obvious, then it is recommended to clearly and carefully document in the transaction documents the such considerations, such commercial benefit, to show how the transaction will generate the value for the seller, including from financial and strategical justification. And while commercial benefit and consideration concepts are well developed under English law, they are not developed in Ukraine. Still, it is recommended to address these matters in the transaction documentation. And finally, there may be also some structuring options which could be used to mitigate the risk, and those were already mentioned, like various hive outs, hive ups, hive downs, which in some jurisdictions are actually available even within the insolvency proceeding. And now just a couple of words in relation to the M&As deals within the insolvency proceedings, and please move to the next slide. So on this slide, you can see various options, various restructuring options available to a distressed company in Ukraine. And they are basically two groups of those. So financial restructuring and pre-bankruptcy restructurings are kind of voluntary restructuring procedures, still requiring involvement of a court. And two last in bankruptcy restructuring and liquidation are generally two stages of the formal insolvency proceedings. And this table actually shows and confirms what has already been mentioned by my colleagues in relation to the pros and cons of acquisitions during insolvency and prior to insolvency. And it's well understood that generally there is more freedom and discretion available to the parties in a transaction that is being done prior to insolvency. And as the key difference that any sale of the assets during the formal insolvency proceedings would be on an auction basis, which means that there would be almost no room for negotiations and no room for the parties' discretion and any choice actually, and there would be of course more competitors during the auction. And this means that it is probably only in relation to some specific assets or specific situations that the purchase of the assets or a company would be more favorable for a buyer within the insolvency procedures rather than outside those. I will not go into further details on this as already discussed, and now we'll pass the floor to Christina, who will cover the aspects relating to the financings that a target may have and what needs to be considered in relation to those.
Yes, thank you, Katya, and hello to everyone. Yes, thank you. Partially the question of financing in the M&A deal was already touched upon by my colleagues, but just to focus on a few steps and peculiarities in more detail. The first thing that you will have to do during such a distressed M&A is basically to identify what existing financing is in place. Existing financing is one of the most crucial elements for both the share deals and the asset deals, because in the share deals it will highly impact the price of such an M&A deal, given that this impacts the financial position of the target. And in an asset deal, financing obviously impacts the assets in terms that such assets may be subject to certain security tied to the existing financing. And the existing financing become even more crucial in case the target is has already entered the insolvency proceedings or formal bankruptcy proceedings, because after a certain point in time, the creditors have either the crucial or the main control over all of the assets of the bankrupt entity. And their consents may be required in order to do any actions with such assets. So when you identify the existing financing, first of all, you have to be aware of various unusual financing that may be in place, such as crowdfunding, cash pooling, and so on. And of course, together with the existing financing, it is crucial to conduct a full financial audit to identify not only conventional lending transactions that the target is a party to, but also other debts that are in place, because especially after the insolvency, all of them will impact the target. Another important point is with respect to the unregistered security. So it's clear that in case the security interests over the assets are registered in the public registers, those are easy to identify, but it is also crucial to ask the target to disclose the unregistered security, because from Ukrainian law perspective, for example, if we are talking about the movable assets, registration of the security interest of such movable assets is not required for the validity of the security interest. And therefore, in case there are any purchase or sale of such assets without the consent of the unregistered pledgee, it might create issues at a later stage with such sale and purchase deal being challenged by the pledgee. Another important point is that you have to check the standstill agreement, because often in case the company is already in distress, the standstill agreements inter alia deal with the terms of sale and of the assets of the company that is in the distressed position. And that's why it is important to take those into account when drafting the SPAs for your deal. And the final point, we'll talk about it in more detail in a minute, is whether you want to keep the existing financing or you want to get rid of it before the signing of the SPA, which will definitely also impact the price. The second step is buy time. What we mean by this is that you would not want to start negotiations with the buyer when in the meantime the creditors with the seller, I'm sorry, when in the meantime the creditors of such seller start some, for example, the bankruptcy proceedings or enforcement proceedings against the asset and basically ruin all of your plans. That's why it is very important to work simultaneously on two work streams. One is the negotiation with the seller, and second is discussions with the creditors of such seller as to how they see basically the future either of the target, if we talk about the share purchase, or of the assets, because very often in asset deals you will need the consent of the creditors to release the security over the assets that you plan to buy. And in share deals, as I said, you don't want the lenders to start the enforcement. Then let's move to the next slide, please. The next step to consider is finally decide whether you want to keep the existing financing and the debts or repay them. So definitely this will impact the purchase price, and if there will be no prior repayment and the financing will be kept, it is crucial for you to review the conditions of the existing financing instruments in order to make sure that these are not onerous and there is nothing outrageous that you would definitely not would like to accept. For example, certain unilateral increases in the interest rates and so on. Alternatively, there's also a possibility to inject funds into the company in order for the company to be able to repay the existing financing, because obviously if it is in distress, it is unlikely that it already has funds available to do so itself. And then we are smoothly moving to the step 4, which talks about that we need to take care of all the consents that may be required in the process of the M&A. In case of the share deal, please pay attention to various, especially if it is a big syndicated financing, pay attention to possible share retention agreements and prohibitions on change of control to make sure that you have obtained all the consent from the creditors to the change of control in the share deals. And in the asset deals, As I already mentioned, please take care about the consents that will be required from the existing lenders to lift the existing security over the assets that you are purchasing. Also, in case you are pursuing a way of injecting new financing into the target, then you may also need a consent from the lender for such injection, because sometimes the debtors are prohibited from undertaking new debt obligations, especially if they are in distress. And finally, the step 5 would apply if you actually intend to make repayment of the existing financing. In this case, you will have to enter into the payoff letter with the existing creditors in order to make sure that you have 2 clear points as to how much should be repaid for the lender to be completely satisfied and confirm the full discharge of the obligation of the debtor. And the second point is how to deal with the security. So basically, for example, you can take over the second ranking security interest over the assets that are pledged towards the first ranking creditors, and then the first ranking will be released once the repayment has taken place, and you will have the security interest over the assets that we are talking about. Then please, next slide. And a few words about the purchase of the non-performing loans. So basically, this would most likely be more of interest to various financial institutions that deal with in NPLs. And a few points to take into account in this respect is first what NPL you are dealing with, whether that's the syndicated loan or a single creditor. In case there is a syndicated loan, usually the process of purchasing such NPL may be longer, and moreover, in the syndicated loan agreements, there may be a special procedure for changing the lender under such loan, and that's why you have to check that in advance, make sure that you can perform the conditions that are required under those terms. Second point is the consent of the debtor. So basically, you have to check whether there is whether it is required in the finance documentation for the debtor to consent to the change of the lender. Next point is security considerations. This is one of the most crucial points, because usually the security is the key interest of any lender purchasing the NPL. That is why it is very important to make a clear due diligence of such security. The security documents to check whether there are no defects in the security documents, whether they are valid. For example, if all disposal consents were obtained. Also, whether the security interests are registered, and so on. The second point here is that you will have to deal probably with registration of the security in your favor, meaning that you will have again to obtain consents from the existing lender. Another point is the structuring consideration, whether you want to pursue such purchase of NPL by way of assignment or brand new agreement. And in this respect, it is crucial to note the clawback period that was discussed by my colleague Katerina earlier, because in case there are brand new agreements entered into, basically the clawback period starts running afresh. And finally, take into account the jurisdictions involved. If this is a big syndicated loan, most likely there will be numerous jurisdictions, and you will have to make sure that your security interests to the assets are perfected in all of those jurisdictions. In some jurisdictions, even the assignment or amendment agreements to the loan agreements have to be also registered. For example, there is also a stamp duty in Cyprus. In connection with the security considerations, you also have to make a good due diligence of the financing documentation itself. So the loan agreements, also to make sure that one, the loan agreements are not defected and are perfectly valid. And second, that there are no provisions that are not satisfactory to you and which you may want to change before stepping into this NPL. And the final point here is the factoring risks. So in case you are a purchaser and you want to purchase the NPL with discount of its premium, there are factoring risks, meaning that you might be required to have a status of a financial institution under Ukrainian law in order to do so. So in case you are not a financial institution, it is important that the value of the loan actually matches the purchase price of the NPL. That's all on my side, so I pass the floor to my colleagues for some closing remarks.
Thank you, Christina. Thank you, everyone. Now this concludes our webinar. We, of course, will be very glad to respond to any of your questions which you have regarding the process of distressed M&A. In summary of what we discussed, I want to stress that basically distressed M&A has a lot of features which are common with general M&A process. However, there are also very important differences. And the differences, as you have heard from my colleagues, they primarily relate to the need to be more attentive to the structure of the deal. You obviously don't have the advantage of time, which you normally have in a normal M&A deal. And the timetable for distressed M&A deal is normally very compressed, and sometimes it is related to the possible insolvency of the company, of the target company. So you need to be really, really well prepared to this process. And obviously this compressed timetable of the deal and all the complexities of the potential insolvency situation and the need to carve out the assets and possibly create additional new structures, all of this makes distressed M&A quite complicated process. Plus to this, you also have financing arrangements which need to be dealt with, and also this adds additional layer of complexity to this whole deal structure. However, because of these difficulties, you also have a lot of opportunities, because at some point the distressed M&A market will reach the tipping point when every deal basically will be a distressed M&A deal. And there is an expectation that this tipping point will come in autumn or later this year, when we will see the financial results of the company for the second quarter, for the third quarter. And obviously this will be a big topic to discuss and to think about. But the important thing is that for any such deal is to have very experienced advisors who can quickly understand the essence of the deal and advise you appropriately how to deal with these matters. Last, to conclude with a bonus to the participants, in June, actually earlier this month, CMS together with Credit Suisse produced a very detailed report on the financial and legal implications of COVID on European M&A activity. We have not included this in the materials, but to those ones who have listened to the end, we will be pleased to send this report if you request any one of the speakers by an email. So thank you for the attention, and we hope to be able to help with your distressed M&A deals in the future, and to communicate with and to deal with your questions and with the requests and any deals that you might have. Thank you very much. This concludes this webinar.